I have been on this bench for a long time, long enough to know that people do not always come into court carrying what the paperwork says they are carrying. On paper, it may be a contract dispute, an unpaid bill, a damaged car, a small injury, or a workplace complaint. But in real life, people often arrive carrying something much larger: pride, fear, resentment, desperation. Sometimes they bring a story carefully built to get sympathy. And once in a while, someone walks in carrying a performance so polished, so calculated, that the first task of the court is not simply to hear testimony, it is to separate reality from theater. That was the situation the morning Karen Whitmore entered my courtroom. She was 48 years old, dressed beautifully, composed on the surface, and carrying a white cane with a kind of practiced fragility that immediately drew attention. She moved slowly, deliberately. Her hand reached into space in a way that seemed almost designed to make every person in the room uncomfortable, for even wondering whether anything about her presentation might be exaggerated. The performance was not loud. In some ways, that made it more effective. She had clearly studied what she wanted people to believe about her. She had chosen the right accessories, the right pacing, the right pauses, the right expression of vulnerable determination. To an untrained eye, she might have looked convincing. But I have spent too many years watching people tell stories from witness chairs and counsel tables to ignore instinct when instinct starts speaking clearly. Karen had filed a lawsuit against Barbara Chen, a 52-year-old woman who owned a small accounting firm. Barbara was not a giant corporation. She was not a faceless employer with an army of attorneys and a public relations team. She was the kind of person who builds a business slowly, carefully, and at personal risk. She had hired Karen 8 months earlier as a bookkeeper. According to Karen's lawsuit, she had developed a rare condition that left her blind, and Barbara, rather than accommodating her disability, had terminated her and forced her into financial and emotional distress. Karen was asking for $125,000 in damages, claiming discrimination, wrongful termination, and emotional suffering. Barbara sat at the defense table looking exhausted, truly exhausted. Not the theatrical exhaustion of someone putting on an act for a judge, but the drained, brittle expression of a person who had spent months paying legal fees to defend herself against something she believed was entirely false. She had already spent $12,000 just trying to keep her business and reputation intact. And before the hearing even began, I could see that she was less angry than stunned. That kind of stunned expression comes from discovering that someone you tried to help has chosen to turn your decency into a weapon against you. The more I reviewed the file, the more my instincts sharpened. Barbara's account was simple. When Karen first announced that she was losing her vision, Barbara had tried to help. Flexible hours, adjusted responsibilities, patience. But then, according to Barbara and several co-workers, small contradictions began piling up. Karen claimed she could not read documents, yet co-workers reported seeing her glance at her phone and respond to messages without assistive tools. She claimed she needed help navigating, yet internal security footage appeared to show her moving through the office smoothly when she thought nobody was watching. There were reports of her driving in the parking lot, reports of her identifying objects at distances that did not fit the story she was telling. When Barbara confronted her gently about the inconsistencies, the relationship collapsed. And shortly after that, the lawsuit arrived. Barbara also described the emotional damage the fraud had caused inside her office. She had a staff of 9 people, small place, family atmosphere. Some of them had gone out of their way to help Karen after the announcement about her eyesight. They had carried files for her, read screens aloud, reorganized desks and walkways, slowed their own work so she would not feel embarrassed. Barbara told me they did all of that willingly because they believed they were helping a colleague through a devastating medical change. Then, piece by piece, they began realizing they were not watching courage. They were watching theater. Nothing poisons a workplace like finding out your kindness has been turned into a resource to be exploited. One of Barbara's employees had provided a statement saying she watched Karen claim she could not read a printed ledger, only to glance at a text message on her phone 2 minutes later and laugh at something on the screen. Another said Karen once asked for assistance walking to the restroom, while at the same time accurately reaching for a coffee mug placed several feet away on a crowded desk. A third employee reported seeing Karen apply eyeliner in a car mirror during lunch. These were not isolated slips. They were the kinds of mistakes people make when they are lying full-time and get tired of remembering which version of themselves is supposed to be present. I take disability fraud seriously, extremely seriously. Not because I enjoy catching liars, though I have no patience for dishonesty, but because false claims like these damage real people. They mock individuals who live with actual impairments. They poison trust. They make employers, insurers, coworkers, and even courts more skeptical when a genuinely disabled person asks for help or legal protection. Fraud in this area does not merely steal money, it steals credibility from people who cannot afford to lose it. Years ago, I presided over a guardianship issue involving a young man who had lost most of his sight after a violent assault. He needed help reading, navigating unfamiliar places, and doing work he once handled easily. What struck me most about him was not weakness, but discipline. Every movement had intention. Every adaptation had cost him time and training. Nothing about his life resembled the broad, melodramatic gestures Karen was performing in my courtroom. Real impairment changes rhythm. It changes habits. It does not arrive like a costume assembled from internet research. So before Karen ever took the stand, I had already done what any careful judge should do when something feels wrong. I had looked more closely. I had asked questions. I had made calls. And I had arranged for the hearing to proceed in a very deliberate way. When the matter began, I asked Karen to explain her condition in her own words. She took a deep breath and delivered a practiced narrative. She said that 6 months earlier, she had woken up and found that her world had gone dark. She said doctors had diagnosed a rare degenerative condition affecting her optic nerves. She said she had gone from independence to helplessness overnight. She described the loss with a careful blend of sorrow and poise, the kind designed to suggest that she was brave enough to endure hardship, but wounded enough to deserve relief. Then she turned toward Barbara and described herself as a loyal employee, discarded the moment her disability became inconvenient. It was polished. It was emotionally calibrated, and it did not move me. What did interest me was the way she used language. Fraudsters often overwrite their hardship. They do not simply say, "I lost vision." They speak in highly packaged phrases. Their story sounds narrated, not lived. Karen used all the right emotional notes, but she did not sound like someone groping for truth. She sounded like someone presenting a product. I turned to Barbara and asked for her response. Barbara's voice shook, but her account stayed focused. She said she had not fired Karen because of a disability. She said she had fired Karen because she believed Karen was lying. She referred to office security footage, witness statements, inconsistencies, social media activity that did not align with blindness. Karen interrupted almost immediately to call the material misleading and discriminatory. She framed skepticism itself as cruelty, which is a very common technique in fraud. If you can turn every factual question into an act of persecution, you force decent people to feel guilty for testing the truth. Then I brought up the medical documentation. Karen had submitted a letter from an ophthalmologist, Dr. Michael Stevens, confirming her diagnosis. The problem was that Dr. Stevens had retired months earlier and had not treated patients during the period in question. I had spoken with his office. The letter submitted to the court bore a signature that appeared to imitate his, but badly. When I informed Karen of that fact, her composure flickered for the first time. She tried to suggest confusion, maybe a different doctor with the same name. But the moment had already shifted. The court now had a forged medical letter sitting in evidence. That is not a clerical error. That is not a misunderstanding. That is design. Even then, Karen did not retreat. She escalated. She insisted she was genuinely blind and accused everyone around her of wanting to shame disabled people for adapting. The language was familiar. She wanted the room to feel afraid of appearing insensitive. But truth cannot be held hostage by manners. If the evidence points to fraud, my job is not to worry about the comfort of the lie. My job is to expose it. So I conducted the first simple test. I asked Karen to demonstrate how she used her white cane to navigate from one position in the courtroom to another. If someone has been living with blindness, especially if that person is relying on a cane, there are patterns of use that become second nature. What Karen displayed was not second nature. It was imitation. She waved the cane like a prop, not a tool. She moved it broadly, awkwardly, without the controlled arc that actual mobility training teaches. It looked like what a sighted person thinks blindness looks like when they have learned it from movies and internet clips rather than lived experience. When I pointed that out, she reacted exactly as frauds often do when they are cornered by specifics. She became louder, more indignant, more moralistic. She said the court was humiliating her. She said this was why disabled people stayed silent. But outrage is not evidence. Volume is not proof. And my patience for manipulative theatrics is very limited. At that point, I introduced another line of evidence. Social media. People delete things all the time, then act surprised when the digital record does not vanish as cleanly as they hoped. Karen had posts and location-linked content that placed her at a shooting range just weeks after claiming total blindness. The images showed her handling a firearm and accurately hitting targets. When I asked how a completely blind person manages target shooting with apparent confidence and coordination, she said the images were old. They were not. Metadata is indifferent to panic. Dates, locations, and transaction records told their own story. There was more. She had restaurant photos in low light where she was reading menus. She had tagged herself at a boutique opening while carrying no cane at all. There was a video clip from a friend's birthday dinner where she turned instantly toward a phone flash from across the table. None of those items alone would have proved the entire case, but together they established a very clear theme. Her blindness appeared to arrive when money, leverage, and sympathy were useful, and disappear when comfort, pleasure, or spontaneity required sight. The courtroom had turned by then, not because I raised my voice. I did not need to. The evidence was doing the work. Barbara sat straighter. Karen sat tighter. The audience moved from sympathy to suspicion and from suspicion to recognition. The only thing left was to make the truth visible in a way no one could deny. That was when I brought in Bailey. Bailey was a golden retriever trained as a courthouse service dog, specifically accustomed to assisting individuals with visual impairments. She entered calmly, professionally, wearing her vest and moving exactly the way a well-trained service animal should. Karen noticed Bailey before anyone announced where the dog was. That mattered. Her posture shifted. Her breathing changed. Her body tracked the dog's location. A blind person could certainly hear a dog enter a room, but what followed was not hearing. It was visual awareness. I told Karen that because she claimed complete blindness and difficulty navigating unfamiliar spaces, we would allow Bailey to assist her from the plaintiff's table to the bench. Karen immediately resisted. She said she did not need the dog, that she preferred her cane. That answer by itself did not prove anything, but taken with everything else, it mattered. Fraudsters often fear variables they cannot rehearse. Bailey was positioned quietly in Karen's path. I asked Karen to walk forward, using whatever method she normally relied on. Karen began moving with exaggerated care, using the cane in the same clumsy way she had before. But when she reached the point where Bailey sat, something happened that ended the question. Karen adjusted her path to avoid the dog before her cane should have detected any obstacle. She did not touch Bailey. She did not react to contact. She simply saw the dog and walked around it. I asked how she had known Bailey was there. She tried to say she had sensed the dog's breathing or the air movement or some heightened awareness. That explanation might satisfy a lazy interviewer. It does not satisfy me. Then I conducted the final demonstration. I had the bailiff bring me a bright yellow tennis ball. I held it up so the room could see it. Then, without warning, I tossed it directly toward Karen's face, not to injure her, to test reflexive visual coordination. A genuinely blind person does not track a fast-moving object through space and catch it cleanly. Karen did. Instantly, hands up, eyes engaged, motion tracked, ball caught perfectly. The courtroom reaction was immediate and explosive. But from my perspective, the important part was not the drama. It was the final collapse of ambiguity. There was no room left for explanation. She had not merely slipped. She had revealed the one thing she had spent months trying to hide: functional vision. When I asked her how a blind woman had just caught a ball thrown at her face, she tried to call it reflex. No. Reflex does not explain coordinated interception of a moving object. Vision does. That was the end of the act. Karen removed her sunglasses. She was crying by then, but not with the polished self-pity she arrived wearing. These were tears of fear, exposure, and the sudden realization that every layer of the scheme had failed at once. She said she was desperate. She said she needed money. She said she could explain. I stopped her. Desperation may explain motive. It does not erase fraud. And what she had done was not one lie. It was a constructed enterprise. I laid out what the evidence now showed: the forged medical letter, the false disability claim, prior filings against other employers, disability payments collected under false pretenses, a fraudulent placard, a pattern, not a panic. By the time I was finished, the room understood that Barbara Chen had not merely been sued unfairly. She had been selected as part of a repeat scheme. Barbara then told the court something that stayed with me. She said the worst part was not the money. It was the guilt. For months, she had worried that maybe she was becoming the kind of employer who failed somebody vulnerable. She had lost sleep, asking whether she had been impatient, dismissive, or unkind. Fraud does that too. It rearranges the conscience of the innocent. It makes decent people question their own decency. That was part of the damage Karen had caused, and it mattered. My ruling was simple: judgment for the defendant. Barbara Chen was cleared completely. Karen's claim was dismissed with prejudice. I ordered Karen to reimburse Barbara $5,000 toward legal expenses. Then I directed that the matter be referred immediately to the district attorney for criminal review, including fraud, forgery, and perjury concerns supported by the record. That was the legal end of the hearing, but not the practical end of the story. The district attorney's office did not need long to understand the scale of what had happened. The fraud visible in my courtroom was not a one-day lapse or a bad improvisation by a frightened woman. It was a system. Once investigators matched dates, filings, payment records, and prior complaints, a pattern emerged that was as deliberate as it was ugly. Karen had not merely exaggerated a medical problem. She had constructed an identity around false impairment and then used that identity to demand money, protection, and legal leverage from anyone unlucky enough to stand in her path. That matters because fraud of this kind survives by feeding on decency. Barbara Chen did what many good employers would do. She tried to help first. She modified tasks. She slowed the office down for Karen's benefit. She asked staff to be patient. She gave grace before she gave doubt. In other words, Barbara behaved responsibly. Karen took that responsibility and treated it like an opening. That is one of the hidden injuries in cases like this. The liar does not only steal money. She teaches decent people to become suspicious the next time real need walks through the door. Barbara later told the court in a written statement that at the start, she doubted herself more than she doubted Karen. She wondered whether she was being unfair. She worried that any hard question might seem cruel. That is how these schemes often work. The fraudster counts on ordinary kindness. She counts on people wanting to appear humane. She counts on the fact that most adults would rather be inconvenienced than risk humiliating someone who might truly be suffering. There is virtue in that instinct, but courts exist precisely because virtue without verification can be exploited. The criminal review uncovered more details than I needed for the civil ruling, but not more than I expected. Benefit claims had been collected, while Karen was publicly and privately engaging in activities inconsistent with blindness whenever convenience required it. Accommodations had been requested with one hand, while performative independence was enjoyed with the other. The same person who wanted legal protection as a suddenly blind employee had no difficulty navigating restaurants, boutiques, social events, and a shooting range when there was something she wanted. Rights were not, for her, protections connected to actual disability. They were tools she believed clever enough to use. That is why I never apologize for scrutinizing cases like this carefully. Some people call that harsh. It is not harsh. It is necessary. A fair court does not assume every claim is true, and it does not assume every claimant is lying. It listens. It compares. It tests. It notices. Sympathy is not a substitute for evidence, and skepticism is not cruelty when facts justify it. The danger lies in being too lazy to tell the difference. After the hearing, many people focused on the dramatic moment with the tennis ball. I understand that. It was immediate. It was visual. It ended all argument in a second. But the ball was only the final note, not the whole piece. The truth was already present in the forged medical letter, the clumsy cane use, the social media trail, the witness statements, and the inconsistencies that multiplied each time Karen opened her mouth. The lesson is not that a clever judge found a trick. The lesson is that falsehood usually leaves fingerprints everywhere, and discipline is what allows a court to see them. I also think it matters that Barbara Chen never turned vindictive. She wanted her name cleared. She wanted the fraud stopped. She wanted to protect the business she had built. But she did not use Karen's collapse as an excuse to become theatrical herself. She remained measured even after spending money she should never have had to spend. That restraint impressed me. It is one thing to be right. It is another thing to remain decent while proving it. As for Bailey, yes, Bailey did excellent work, calm, focused, properly trained. But the deeper value of bringing Bailey into that courtroom was educational. People saw, perhaps more clearly than they ever had, that blindness is not a collection of dramatic gestures. It is a lived reality with practical consequences, routines, and skills. Real service animals are not costumes. Real mobility tools are not props. Real disability is not an aesthetic. Fraud collapses fastest when reality is allowed into the room. Months after the case, I received a short letter from someone who works with visually impaired adults. The writer thanked the court for handling the matter firmly without mocking blindness itself. I appreciated that very much. The point was never to ridicule disability. The point was to defend it from imitation. There is a difference, and it matters. So when people ask whether I would handle the case the same way again, the answer is yes, without hesitation. Karen Whitmore entered my courtroom expecting performance to outrank proof. She expected discomfort, politeness, and fear of appearing insensitive to do the work her evidence could not. She expected a hardworking small business owner to be easier to crush than the truth. She was wrong. Barbara Chen left with her name intact. The record reflected what had actually happened. The matter was referred where it needed to go. And every person in that courtroom was reminded of something simple but essential. Compassion and gullibility are not the same thing. A justice system that cannot tell the difference will fail the very people it is supposed to protect. That is why I do not lose sleep over how the hearing unfolded. I sleep very well. Because when a lie this elaborate comes into court wrapped in borrowed suffering, the most humane thing a judge can do is expose it before it harms anyone else. And if that exposure feels harsh to the liar, it is only because truth finally arrived, wearing the authority she tried to counterfeit.